Unit 2. Provisions that regulate employer-employee relation. In the second unit, you will be introduced to the national legal acts and European Union provisions in the fields of labour market and work law. The European Union seeks to promote social progress and to improve living and working conditions for European citizens. It encourages free movement of goods, services, capital and workers. Regarding free movement of workers, it defines: the free movement of workers gives every citizen of the Union, irrespective of his or her place of residence, the right to move freely to another member state in order to work there and/or to reside there for work purposes. It protects them against discrimination on grounds of nationality as regards access to employment, conditions of employment and work, in particular with regard to remuneration, dismissal, and tax and social advantages, by ensuring their equal treatment, under national law, practice and collective agreements, in comparison to nationals of that member state, Directive 2014/15/EU of the European Parliament and of the Council of 16 April 2014 on measures facilitating the exercise of rights conferred on workers in the context of freedom of the movement for workers. 2.1.2. Yours. Freedom of workers' movement in the European Union opens new possibilities for finding appropriate employees with certain knowledge and skills in any of the EEA states. With that purpose, the Yours web portal, European Employment Service, was established, with the aim of facilitating free movement of workers within the relevant countries. Partners in the network include public employment services, trade unions and employer organizations from each of the EEA states. The Yours portal enables connections between employers and job seekers from all the participating countries. All companies, employers that wish to advertise vacancies in Slovenia, need to have their vacancies managed by the Employment Office of Slovenia. When foreign direct investors wish to employ or search for workers in the EEA area, refer them to the relevant Yours web page. National legal regulations on which employer-employee relations and working contract are based. Labour legislation. Labour relations in Slovenia are defined by labour legislation, if they are not defined differently by other laws or international contracts which are concluded and confirmed in accordance with the Constitution of Slovenia. The most important laws are: the law on employment relations, the law on employment and unemployment insurance. As FDI advisor, you should also study the law on employment, self-employment and work of foreigners. Collective agreements. A collective agreement is a written agreement between workers, represented by the union, and one or more employers' association, which has a legal effect. Collective agreements define rights and obligations. Those that are not defined in detail by labour legislation are established by collective agreement. For example, these rights and obligations include: annual leave regarding workers' occupational record, salary accounting based on workplace classification, various tax-free reimbursements and other rights. Workers' and employers' obligations are established, and rights are protected with the goal of achieving equal status of workers in the same profession. Some of the professions in which collective agreements are established are commerce, hotel and catering industry, construction industry, wood industry. If employer's business field is in profession for which collective agreement is in force, he is obligated to apply it. List of the collective agreements is published on the web pages of Ministry responsible for Labour. Income tax law. The income tax law defines the tax rates for residents and non-residents of Slovenia who are receiving taxable income in the country. It also defines possible deductions and workers' right on tax-free reimbursements, authors' royalties, other income, pupils' and students' payments, etc. Minimum wage law. The law prescribes the ways of defining minimum wage. That is the lowest amount of gross salary which belongs to an employee for full work time. Full work time is 40 hours per week. Retirement and disability insurance law. Ways of employees' registration and dismissal, as well as changes during employment, are defined by the Retirement and Disability Insurance Law. Healthcare and Insurance Law. Among other, the law defines the rate of health insurance that needs to be paid by an employee and an employer within the monthly payroll. Labor regulations. Labor regulation is an internal document extending the scope of the rights and obligations of an employer and an employee in their mutual relationship, which are not covered by the rest of the labor legislation. For an employer employing 10 or more employees, this internal document is mandatory. However, an employer who does not have a statutory obligation to establish labor regulations still has the interest to draw it up in order to protect his interests in specific situations. For example, an employee terminated an employment contract shortly after he started working. His employer was legally obligated to obtain all necessary certificates needed for work on his expense, which the employee could use with another employer until their expiration. By accepting labor regulations, an employer can protect himself and obligate an employee for a refund of the whole or a certain % of this expense. Labor regulation must not be in conflict with any of the other provisions of labor legislation. Before signing an employment contract, an employer is obligated to inform his employee on the labor regulations, if there are any, in order for him to read and sign it as a sign of his accepting of the rules. Employment of foreign nationals. The employment of foreign nationals is arranged by the Employment, Self-Employment and Work of Foreigners Act, ZZSDTUPB 2, Official Gazette 1, 2018. This act lays down the conditions for the employment, self-employment and work of foreigners and the related tasks of the Republic of Slovenia in regulating and protecting the labour market. The Republic of Slovenia shall conclude international agreements by which it defines the conditions for the employment, self-employment and work of foreigners and shall adopt measures defined by this act to protect its labour market. Based on Employment, Self-Employment and Work of Foreigners Act, the Government of the Republic of Slovenia every year issues a regulation on the determination of the work permit quota which limits the number of foreigners on the labour market. The quota of work permits is determined in the total amount of 12,000 work permits and is intended for foreigners who do not have a residence permit in the Republic of Slovenia and for foreigners who are employed on the basis of a work permit after the end of the seasonal work. The quota does not include work permits issued to nationals of the member states of the European Union, the European Economic Area or the Swiss Confederation and their family members, irrespective of their nationality, provided that work permits are issued on the basis of the agreements concluded. Foreigners for whom work permits are not prescribed by law. Foreigners with a personal work permit. Agents, and foreign posted workers for additional education. A quota of 11,000 work permits is distributed according to the purposes of 8,800 employment permits for the employment of foreigners, 1,500 work permits for seconded foreigners, 100 work and training permits, 500 work permits for the seasonal work of aliens, and 100 work permits for individual services provided by foreigners. In the conversion of the quota, at least 50% of the reallocated quota shall be allocated for the reallocation of part of the unused quota for the employment of foreigners according to the priority list, namely 95% for foreigners resident in the territory of the countries of Bosnia and Herzegovina, the Republic of Montenegro, the Republic of Croatia, the Republic of Macedonia, and the Republic of Serbia, excluding Kosovo, and 5% for foreigners resident in the territory of other third countries, including Kosovo. In the event that the quota for a work permit is used, 11,000 permits, the Ministry of Labour, Family, Social Affairs and Equal Opportunities may, in the framework of an undistributed quota, further distribute 1,000 work permits, but only to a foreigner with education comparable to at least higher education or higher professional education at the 6th level in accordance with the regulation on the introduction and use of a classification system of education and training, to which the employer will pay a salary of at least 2.5 minimum wages. If the employment service, which implements the supervision of the implementation of the regulation, finds that an employer does not pay salaries in a certain amount, the employment permit is annulled and the employer is not allowed to issue new employment permits during the period of validity of the regulation. Any changes regarding the employment of foreigners, including quotas, are publicly announced by the Employment Office of Slovenia. Referral to work abroad and rights of posted workers. Posted workers are persons employed by an employer with a head office in Slovenia sent to work or to professional training abroad if they are not compulsorily insured in the country to which they were sent. At the time of posting, posted workers and self-employed persons who carry out similar business in another country remain included in compulsory social insurance in Slovenia. Employer or a self-employed person in Slovenia pays contribution from all remuneration from work or activity. The posted workers and self-employed persons have the right to cover the costs of necessary services and use them in another country at the time of posting. In the case of EU countries, Iceland, Liechtenstein, Norway, Switzerland, Bosnia and Herzegovina, Montenegro, Macedonia and Serbia, this right is exercised through a European health insurance card. Posting and enforcement procedures vary whether a person is posted to work in EU member states, Iceland, Liechtenstein, Norway and Switzerland, or countries with which Slovenia has bilateral agreements on social insurance, Bosnia and Herzegovina, Montenegro, Macedonia and Serbia, or countries that are not subject to the European legal order or bilateral social insurance agreements. Before the referral, employers and self-employed persons must obtain a certificate A1 for each posted worker at the Institute of Public Health, ZZZS, by which the worker in the seconded country shows that the regulations on social security of the Republic of Slovenia continue to apply during the cross-border implementation of the service. FDI advisors should inform their clients that penalties are high, even after a company is closed down, in case of an unregistered employee, employment contract that is not coordinated with legislation, employees' late registrations, payment under minimum salary, non-payment of salary and legal obligations, employment contract manipulations or even contracts that were filled out incorrectly or not completely. Inspection is made by Labour Inspectorate of the Republic of Slovenia and Financial Office of the Republic of Slovenia.